go live.
And we are live on AUS Property Investors. We bring the big names and we have the big fun. And we bring the cricket post. Oh, sorry, I was admiring your painting again. It's exciting times. How you going, Richie?
Very good, thanks, Jeff. Pleasure to be here.
I thought you were about to crack into like, oh yeah, we're at the cricket 2 for 222. Sorry,
Richie Banner, yeah.
I'm a cricket tragic, so I apologize. How you going anyway, Joe? What's
Mate, I'm fantastic. I got my fun shirt on. You know, we're going to be talking about legal. We're going to be talking about the law. We're going to be talking about contracts. Jeff, you even brought your own fun shirt. Richie's bought the fun poster. It's going to be a high value session. It's one of these sessions that I think that it's not going to be the most entertaining. I think we're going to be up there, Richie. Don't get me wrong. Law is I used to work in the legal space and I know. And so, but I think it's going to be some of the more high value ROI listening that you're going to get as a property investor. So if you don't understand these things about contract law, you're going to make some mistakes. So I'm going to say maybe not the most exciting, but ROI, return on listen, ROL, you're going to be doing pretty good for yourself.
That's saying about the hole, Joe. When you're digging yourself, the best way to get out of a hole is stop digging and just step out of the hole.
Mate,
no, I think it's going to be.
I think it'll be fun.
Yeah.
Listen, law and particularly conveyancing law is not sexy, but it is important.
100%. Without it, we wouldn't have deals done.
Exactly. Yeah. And I think there are ways and just, I'm sure we get into, there'll be some creative questions for on that point. If anybody's got questions, comments, please drop them. And if you're on YouTube, hit the like, do all that sort of good stuff, because that helps us. We're nearly at 800 subscribers. Let's get to 1,000 by the end of September, or only just starting September. So anyway, let's get into the quote of the week. So Richie, have you prepared a quote for us? I hope.
Yeah, some oldies but goodies. There's actually two that I thought of one, and then I thought of another one that sort of flowed through quite well. And it was loosely related to law, but I think has a broader appeal too. And the quote was, "A person who represents themselves has a fool for a client." And my understanding of that is, you need to take the emotion out of decision making and rely on expert, unbiased advice. Mm-hmm. And following on from that, the second quote was, "If you think it's expensive hiring a professional, then wait till you hire an amateur." So obviously, mistakes can be very costly. So really important to get the experts involved when you're buying property.
Yeah. That's that applies to most things in life, doesn't it, Joe?
100%. Yeah, I think especially with conveyancing as well. If you I actually think conveyancers and the contract review side of things is one of the most crucial members of the team. So if you're not doing that stage correctly and making sure that you're getting the right people and the right advice, it really can mess up everything for you. So I'm all for that quote. What about you, Jeff? What's your quote of the week, my man?
So I looked up. I was going to go with some funny ones, but I thought I'd go with something a little more tasteful. And mine is, "Until the contract is signed, nothing is real." And of course, that's not advice, folks. I'm not saying that life isn't real, but yeah, that was by an American musician, Glenn Danzig, and I think it was sort of apt because, yeah, I'm not a big fan of Glenn, but just never really heard the guy. But I just think that is so apt to sort of, because and we'll talk to some of those points about acceptance and execution, and it varies from around the place. So I'm excited to unpack that. What about you, Joe?
What about my quote? My quote is somewhat related to this, and this one's by JFK, if anyone knows who he is. Let us never negotiate out of fear, but let us never negotiate out of fear, but let us never fear to negotiate. And I think understanding where the contract is, what the next steps are in that contract, and where you can and where you can't negotiate makes a massive difference to the outcome of your purchase. So having that is 100% needed. That is my favorite little JFK quote. I'm sure he has some bangers, but that's certainly on the top of my list.
Let's do it.
Okay.
So
So you, Jeff.
Oh, I was just going to say, shall we? Because I'm excited to introduce Richie, but before we do, of course, we have to pay the bills, Joe. So, shall we? Before we introduce the person of the hour, let's get Richie. He sent me a cracking bio, but let's go, Joe.
This live session is sponsored by Scott Agate from Hello House. Scott has created the world's first property negotiation as a service business. So what does that mean? Well, let's think about it. When was the last time you negotiated on anything over $100, let alone a property that is going to be one of the biggest investments of your life? The vendor, they have a trained negotiator on their side in the form of a real estate agent. That's kind of like you stepping into the ring with Mike Tyson after never training a day of boxing in your life. These guys are trained professionals, and that's what they do day in and day out. And this is what Hello House does every single day as well. They negotiate on property to get the best buy price from the real estate agents. Scott Agate, he's the expert negotiator. He has been in this industry since 1995. He owned and operated 3 Bell franchises. Scott was the guy that was teaching these real estate agents all these agent games. He knows all of their tricks. Having him on your side is going to give you a massive unfair advantage and literally save you tens of thousands of dollars. Unlike other ways of purchasing property, Scott's incentives are aligned with you, the buyer, meaning the more money he saves you, the more money he makes, which is what you want. You need to have those incentives aligned. Scott has kindly offered our group a massive discount on the retainer fee for his service. So if you're looking to buy your next home or investment property, click the link below to get in touch.
So Joe, we've got good idea. Scotty's done some updates. So I've popped a different link down. I popped the link down there for his new kind of thing. But we got to get those updated. But yeah, definitely he's making some noise with that get buy ready. But yeah, the person. So Richie, you sent me a great bio, and I think that the exciting thing about you is you've travelled a little bit. I was looking into your bio because I was trying to find one before. But you are an experienced lawyer specialising in property law across multiple states. So I build you as the nationwide, one of the few people who knows things around the grounds, because a lot of conveyancers, a lot of lawyers, they don't necessarily they know their own jurisdiction and they put a lot of disclaimers around it. But you are the legal director at Law Lab, and you've managed over 50,000 conveyancing transactions. So that's amazing. Like 50,000, that's a lot of properties, or a lot of transactions go through. You're on the board of Pippa, and you also, I think one of the most exciting things is you've done some travel in Europe, but you now call Brizzy home, and you juggle bringing up 2 young daughters and playing footy. So, yeah, a busy guy. When do you find time to actually settle all these 50,000 transactions you've been on top of?
Yeah, we've done a lot. I joined Law Lab about 8 years ago now, when Law Lab had the idea to go national, and there was prior to that, my background was in Queensland property law, and so I had a lot to learn, pretty fast. And we really wanted the only true national conveyancing firm. So it means I have to be across all those jurisdictions to manage the team.
Yeah. So with the question we like to ask, and we were talking about this beforehand, and you've got an exciting journey. But tell us about your first, tell us about your first property purchase, and then a little bit of color to the rest of the journey as well, because you've done some exciting things before we get into the real goal. Yeah,
well, I guess it's going back a while now, but I went to university in Glasgow, Scotland, and my dad had always encouraged me and my brothers to buy property. And so when I was 19, I managed to scrape together enough of a deposit. It was really a bit of a student loan, together with my younger brother. And we bought a Glasgow tenement, so essentially a flat in Glasgow, east end of Glasgow, unpopular at the time, but very close to city centre, a suburb called Denniston. Believe it or not, now in the top 10 coolest suburbs in the world, according to Time Out magazine, which you never would have thought at the time. But we bought that for like £49,000, and ended up renovating it after a few years and doubled our money on that. So that was the first purchase, and served me well during university, and moved over here, bought another apartment in Morningside in Brisbane, held that for a couple of years and sold that. and then I bought a family home in Wooloowin. We renovated, sold. After that, we actually did some property development, small property development. So there was a 1:4 subdivision with builds, and that was a joint venture project. We did another one in Sunnybank as well. That was a 1:2 with a build. And then in the home I'm at the moment, in Hendra in Brisbane. So we bought and we lifted and renovated, as a lot of Queenslanders do, to modernise the home. And more recently, we've bought a investment property in Wavell Heights. So yeah, so a bit of a journey there through property, and of course, professionally been exposed to property investment for over 15 years now.
Wow, that's amazing. So
we could just do a session on that.
Yeah, exactly.
Lots of learning.
Yeah. Well, what's the kind of? It's interesting that you went just straight into development, pretty much. Like you bought one, and then, well, I imagine you sold the Glasgow one, and then came over here and just went straight into it.
Yeah. Well, the developments. So I came over here in 2006. I should say, came back here in 2006, and started doing developments. Probably it would have been about 7-8 years ago. But my professional experience is in, like, my niche is in property development. So I act for developers. So I see all the mistakes they made and all the good things they do, and was able to learn from that, and do a few small projects.
Yeah, what are some of the more common mistakes that you see entrepreneur developers make? Like, what are some of the low-hanging fruit so we don't have to go for them?
I mean, property development is a game of finance, so getting the finance right is important. Getting the right product, and it's really about feasibility as well. So finance and feasibility, making sure you got the numbers right, that you have accounted for all the costs, and that you can sell it for more than you're spending it. Simple as that. So they're the key things. And in the current climate, developers are having problems because of the increase in construction costs throughout the industry, and that means they're terminating contracts, or they're using the termination rights in contracts to negotiate price increases with buyers. So there's a lot of risk when buying off the plan, but there are some things you can think about to minimise that risk as a property investor. Okay, well, you're teasing us here. We can talk about that. I mean, we can jump into it now. It's
Joe loves talking about off the plan. Let's go.
Yeah, that's one of the things I wanted to have a bit of a chat about. Like, let's talk about maybe not just property investing as a whole, but more about like the off the plan space and house and land packages. Like, what are some of the challenges that you see in that space from a contract standpoint?
Yeah, so from a property investor or property buyer standpoint, obviously, if you're buying off the plan, you could be waiting, a year or several years before it's completed, it registers, and you settle. You usually pay 10% deposit in that time. Your money's sitting there. I know that I know a lot of people who have bought off the plan a couple of years ago. The market has risen in that time. They might have bought a $800,000 townhouse, for example, off the plan. Now worth $1 million, but the developer says, sorry, the construction costs have increased so much that it's commercially unviable for us to complete this project. For that $800,000 price. We have to cancel your contract. So, that's devastated a lot of people. The price out of the market is that $800,000 budget they had. Well, that's going to buy them a lot less now. So that's a big problem. And what can investors do about it? Well, there's it depends on your bargaining power. So, in a hot market, a developer knows they don't have to negotiate contract terms. They'll just sell to the next person who's prepared to buy on those contract terms. So you don't have a lot of bargaining power in a hot market, but when the market cools, you do have a bit more, so you can leverage that and say and ask for a few things. For example, one thing is called we've all heard, probably most of us have heard of a sunset clause, which is a sort of a maximum date, and the developer can or you can terminate. When some states the developer can terminate or can get a court ruling to terminate. But a sunrise clause is less well known, and what that means is that as the buyer, you can insert a clause in contract saying that if you don't start construction within 6 months, then I can terminate the contract, which means you're not locked into a contract for years without any control. So yes, sunrise date is something we're recommending a lot of off-the-plan buyers consider.
Yeah, and like, are they accepted by builders and developers?
Each their own. It depends on the bargaining power, and it depends on how confident the developer is. It depends on on what stage in the cycle they're at. Buying for plan, you could be buying from just inception stage, or you could be buying when they're about to turn soil, or you could be buying after the start of construction. So it does depend.
Yeah. And of course, like, if a builder isn't willing to do that and they flat out refuse it, maybe you're going to dodge a bullet because they're not actually going to go through. They're going to potentially hold on to a site. Hopefully they get you in, and then they'll do the development if it makes sense for them. But if it doesn't, then they'll pull straight out. Maybe you are dodging a bullet.
Yeah, and there's been media reports of developers in the past who have deliberately delayed completing developments because they know they could terminate under sunset clauses. That's still the case in Queensland. They still have to act reasonably, of course, but it's difficult to prove that a developer has acted unreasonably. In other states, Victoria and New South Wales in particular, they've obviously changed the law since then to make it harder for developers to terminate off-the-plan contracts.
Yeah, okay. So that's, when did they do that, and how is that different to other states? Like, so
in New South Wales, for example, if there's a contractual sunset date, the buyer has the right to terminate. If the property is not completed, registered, and settles by that date, the developer can't decide to terminate themselves without the buyer's consent or without getting a court order. So it is much harder for developers, and it kind of stops those developers unreasonably delaying completion.
Wow.
What's the reason because I know, I think the history behind that is in New South Wales or Sydney, there was a big kind of property 2013, 2016. A lot of developers were doing that because you sort of saw increases of 300 to 400 to 500,000 in that time period. How come other states haven't brought themselves into line with that sort of clause, or just haven't felt the need? Or what?
Well, as we may talk about tonight, there's a lot of differences between states in property law and conveyancing, and a lot of laws haven't been updated because there isn't the political will to do so, and usually there's only political will if something bad happens and people complain enough about it. So you'll find varying degrees of differences between the states.
Yeah,
maybe that's a segue into some of those differences.
Let's do it.
Yeah, let's go through it.
You want to bring up the purchasing process, Joe, and we can.
Let's do that.
Here we go.
Can you see my screen here?
I can. It's like a Zoom meeting, Joe.
It's like a Zoom meeting. Okay, so this is Law Labs, your purchase and conveyancing journey. So maybe we start here, part A. So I think this will be a good foundational understanding around what the exact process is, and then we can start chatting to where the different things come into play.
Yeah. So the first thing I would think about if I'm buying property is who's going to buy it. So as a property investor, you've got to. It makes sense. That there are different options when you're buying. So are you going to buy in your own name? Are you going to buy in a company? Are you going to buy in a trust? Are you going to buy with the SMSF? And there's a lot of factors to consider when doing that. And, we probably have a whole session about asset protection and structuring in that regard. But, there's pros and cons of each. So buying in your own name makes sense if the property is negatively geared, for example, because you can obviously deduct that from your tax. But then if you own everything in your own name, you might get higher land tax. Or if you own everything in your own name, there's more legal risk, because if you get sued personally, all your assets in your own name are at risk ultimately. So, pros and cons. Company, relatively easy to set up, but by doing a company or trust, you're siloing each asset or ring fencing each asset, so that from a legal risk point of view, if you get sued, whether in your professional capacity or as a landlord, then only that asset is at risk. Or if you get sued personally, all your assets in companies and trusts are protected. Of course, you're not protected against the bank. The bank will always want a personal guarantee. So that's the number one thing. Think about which entity you're gonna purchase in, and that might mean a visit to your accountant first, because tax plays a big part of that. And accountants can set up the structure for you if you need a company or need a trust. Or there are plenty of online providers, both accountants and lawyers, who can set those up very quickly and quite cheaply. Of course, the downside to having a company trust is you're going to have to, there's setup costs, and there's annual costs as well. You're going to have to do annual tax returns for each of those entities. So see your accountant or lawyer, work out which entity. If you don't decide that until after you've signed the contract, there can be stamp duty implications in some states. So here are some of the differences, for example. So, Queensland is the biggest one. So you can end up paying double duty. Like if I was to buy a contract in my name, sign the contract, and then later want to change it to my family trust, then there's potential double duty. So what you'd have to do is ask the seller to rescind that original contract and enter into a new contract in that new name. And there's obviously legal costs and time and the uncertainty of the seller agreeing to that. They may not agree. They might think, well, I probably sold that a bit undervalued. I'm not going to allow you to do that unless you pay me more, or I'll just sell it to someone else. So it's really important to work that out before you sign a contract. In other states, it's not so bad. In Victoria, South Australia, common law right to nominate a nominee after the contract is signed. That's not an issue unless there's additional consideration paid by the other party. But in this example, we're talking about related parties, right? So it's you or your company of trust. So there's no issue with double stamp duty there. Same in New South Wales, is a transfer non-conformity. So as long as it's a related party, related company, related organisation to you, there's not going to be stamp duty. So depending on where you're buying, you really need to make sure that you're getting the right buying entity set up before you sign the contract. The next thing to do is really get that contract reviewed. So you found the property, negotiate the price, or maybe it's an option. Get that contract reviewed before you're bound by the contract. You're obviously only legally bound by a contract when it's signed by both parties, or if you're the winning bidder at auction. So you want to choose a lawyer who can review the contract quickly and give you good advice. We get a lot of clients who might call up on a Thursday or Friday for a weekend auction and need a contract review straight away. So
when somebody's about to go to auction, what are you typically what are you looking at in the contract? Because they're probably quite standard. Is there any kind of gotchas in an auction contract apart from that if you are the winning bidder, then you're on the hook essentially, aren't you?
Yeah, well, there's a lot less room to negotiate an auction contract. But in some states it is practice to do so. So New South Wales, for example, it's not uncommon to ask the vendor to agree to certain terms before the auction. If they do agree to those terms, they have to offer those terms to everyone. So usually at auction there'll be a separate special conditions page where they've agreed to X, Y, and Z. So but an auction's usually 10% of the purchase price, but you can negotiate a lower deposit. You might negotiate that's paid a day or two after auction. But, and once again, differences between the states, but, in New South Wales, there's a standard contract, so to speak, but every lawyer has their own version of special conditions, which can substantially change the contract terms. Things to think. A big one is actually special conditions whereby the buyer is agreeing to the deposit being released to the vendor before settlement. Now, that's a big risk for a buyer. What if the vendor ultimately can't settle? If you've agreed to release the deposit to them, they may have already spent it. How are you going to get it back? You're going to have to sue them, which is costly and uncertain. Yet in other states, there's actually statutory processes for release of deposit, like in Victoria, Section 27. Once it goes unconditional, and as long as the vendor has less than 80% LVR on their mortgage, and a certain time period has elapsed, then the vendor is entitled to that deposit. And that's set up essentially so that vendors can sort of use that deposit to then go and buy another place. So there's a lot of variances around there. But with an option contract, of course, there's no cooling off period. So just on that, for example, cooling off periods vary dramatically across the country. So I guess rule number one is there's no cooling off for an option. But outside an auction,
rule number two is you don't talk about the auction, or don't talk about auction. Sorry.
Well, and it's not just the auction day. If a contract is signed, and this varies between states, but a day or two either side of auction, it's also considered under auction conditions. And
interesting. Okay, because I thought that because if it gets passed in or whatever, if you're the first person who's negotiating, so yeah, I've never actually bought auctions, so I'm exposing myself there to saying that. But can you actually say to a vendor, hey, look, I'm happy to offer this, but I don't want it to be under auction conditions, or what rights do you have to negotiate there?
Ultimately, you can negotiate anything. You might negotiate finance condition, inspection condition. You don't always have to rely on cooling off. With cooling off, you have to pay a cooling off fee in most states. So in New South Wales, in Queensland, it's 0.25% of the price. So $2,500 for $1 million property. In Victoria, it's the greater of $100 or 2%. Sorry, 0.2%. And in South Australia, it's like $100. It's either the deposit or $100. Often it's nothing, because in practice they don't pay that until after cooling off. WA has no cooling off, and so if you're buying by private treaty, it's very common practice to go to contract, and they call contract in WA often acceptance, but it means the same thing. So one party's offered, the other party's accepted, they've formed or exchanged a contract. No cooling off there, but often subject to finance and building pest inspections. And they often have longer periods for that in WA, so like 28 days for finance, 28 days for building pest inspections.
But the pest and building inspection is for only structural defects, isn't it? Rather than just, hey, I want a discount on this purchase price. It needs to be structurally falling down for you to exit out of that contract.
Yeah, there's big differences between states with the terms on a building pest. So, as you said, WA structural is a sort of the standard. You can always negotiate, different special conditions, but that's the sort of industry standard, similar to Victoria. But in Queensland, for example, it's very popular to have a building pest inspection. The buyer just must act reasonably. What does that mean? Does that mean if there's a hole in the wall, it's reasonable to crash the contract, or does it mean something more than that? So there's often disputes in that, but ultimately it's quite hard for a seller to dispute the fact that buyers terminate under building and pest in Queensland. So yes,
and in South Australia, I see a lot of people not having, like, we do a lot of buying down there, and you don't have a pest and building clause in your contract because it makes it cleaner, but you just have the pest and building during the cooling off period. So you just say, hey, great, we got this contract. All it is 14-day finance, and that's it. No other conditions. And then during the 2-day cooling off period, which allows you to get out for whatever reason, essentially you can cool off. And as you say, there is $100 fee that you should pay, but I've cooled off a couple of times. I've never been asked it because we haven't exchanged anything. There's been no money put in, so they can't keep anything. But it's very
in South Australia. Yeah, in South Australia, the cooling off period only starts after you receive the Form 1 vendor statement. And that's 2 business days after you receive that. And the practice in South Australia is you might sign. Ideally, in practice, the sellers set it up so that there's a contract and a vendor statement ready for buyers, and they can get that cooling off period started straight away. But sometimes vendors don't want to spend the money because a Form 1 vendor statement has a lot of searches attached to it. Searches cost money, and you need a lawyer or conveyancer to prepare that. So sometimes they only issue the vendor statement after a contract's been signed, and the cooling off period only starts after then. In other states, ACT, for example, they have what I should explain to everyone is there's kind of 2 main regimes in Australia. There's the vendor disclosure regime states, and there's the buyer beware regime states. So it's about 4 and 4. So New South Wales, Victoria, South Australia, ACT, vendor disclosure states. Different levels of vendor disclosure, but that means that with a contract they need to attach a bunch of searches and disclose things about the property that a buyer should be aware of.
Yeah.
On the buyer beware regime states, as it says, buyer beware. So there's very limited searches or disclosures about the property, and the buyer must then do the search on the property themselves at their cost. And so, Queensland, if you're buying a house, standard RQ contract, there's nothing attached to that really. There's a bunch of warranties. So the seller warrants that the property is not affected by X, Y, and Z. But how does the buyer find that out? They have to do those searches themselves.
And what searches would you typically? Obviously depends on what type of property it is. Like you do a different search for houses versus strata title properties. But what searches would you do you typically get for clients?
Yeah, so just on the strata stuff, there's some disclosures for strata title. So in Queensland, you get those disclosure statements. In WA, you get some disclosure statements as well. But yeah, going back to what searches for a normal house, if I was buying an existing dwelling, for example, I'd want to know that there weren't. You do the basic ones, obviously your title, your plan, so you know where the boundaries are. Land tax, because land tax carries with the land. You want to make sure it's fully paid at settlement, and you want to do rates and make sure outgoings are paid. So they're sort of your real basic standard ones, what we call compulsory searches. You need those to settle, but then there's more optional ones or recommended ones. So if I was buying a house, I would want to know that you're not going to put if it was near a busier road, I'd make sure that there's no the council or the state government don't have any plans to widen that road. And because they want to widen, they're going to resume your house and knock it down. You get compensated for it, but the compensation may not be.
How do you do
sufficient.
That kind of search? How do you find that stuff?
Yeah,
out?
transport main roads. So transport main road search, for example, you apply for that search. It comes back and says we do not have any current plans to compulsory acquire this property. And that's current, obviously, so it doesn't mean to say that in the future that they won't do that.
Yeah.
And then I always say the question I always ask buyers is, have there been any alterations to the property since it was built, or any recent alterations? So have there been any renos? Have there been any extensions? And if there have been, you want to make sure that they've been approved. So unapproved structures are a big one. Because ultimately they may not, if they're unapproved, they may not have been built to code. They may not be safe. Your insurance may not cover you if there's an incident that happens because they weren't approved. most insurance policies saying that, we're saying that your building has had all approval. How would you know? So you can do a search. Most councils have records, at least going back, 10, 20, 30 years for some councils. So you can do a search on whether there's been any building applications, and it's not just whether they've had those building applications approved, but it's whether, because you can have something approved and then you go and build it, but how do you know it's built to what was approved?
Specification.
You have to get it certified. So final certification, final inspection. So you want to make sure, and you have to order multiple search. You have to order a search for the approval, a search for the final inspection in some councils. So that's how you protect yourself. But in the buy beware states, just because there's an unapproved structure doesn't mean that you can cancel the contract. Certainly in Queensland, which is why you want to be, if you think that applies to your property, and often you don't have time to do these searches before you sign a contract because they can take a week or 2 weeks to come back. You want to be thinking about adding a due diligence clause in your contract. So due diligence means that you can do a bunch of investigations of the property. If they don't come back to your satisfaction, you can cancel the contract and get your deposit back.
Is it? I mean, with due diligence clause, I've got kind of 2 questions around that. Is it true that you could say? I mean, obviously, you're not going to say this to the other person's solicitor, but let's just say you go in one day and you don't like the color of that wall. Could you then say, "I'm pulling out of this because I don't actually like the carpet or whatever it is. That's my due diligence. I don't like that property."
Yeah.
I mean, is that
most due diligence clauses are broad enough for you to terminate for any reason whatsoever. Often you don't have to give a reason. You just say, "Okay, we're not satisfied with our due diligence."
I thought there may have been a bit of myth that you could actually sort of, but yeah, sort of. I'm now sort of having that confirmed. The other thing is, given you've sort of seen a lot of transactions, are you sort of, and we've had a pretty hot market, are you sort of seeing a lot of vendors sort of saying, well, no, we're not willing to accept the due diligence clause because, is that something you're seeing a lot of?
In a hot market, why would a seller agree to a bunch of special conditions when the next buyer isn't asking for those? So it's a balance. A lot of lawyers will say, oh, you must have this, and this. And you shouldn't buy property without those things, but you've got to be realistic. In a hot market, you've got to balance risk versus opportunity. So whilst it's important to have those clauses in some situations, you might weigh up the risk and decide that it's not worth doing. Otherwise, you lose the deal. In a slower market, you have much more opportunity to ask for those conditions and be much more diligent with your purchase.
Yeah, everything's more negotiable when you're in a slower market. When you're in a hot market, they've got people knocking down their doors to buy the property, so you need to be fast and have a good enough deal that they want, and then the contract clauses are not too crazy where that scares them off. Because otherwise they're just going to go to the next place. Go to the next person.
In particular, New South Wales, in particular, in Sydney anyway. It's industry practice that when you exchange on a contract, it's unconditional. So the buyer doesn't have the benefit of a finance clause or building pest clause or due diligence. They don't have the benefit of cooling off because most agents will say you need to waive that cooling off, a section 66W, that your lawyer or conveyancer needs to sign to say we've advised this buyer that they usually would have a cooling off period, but they waive it in this instance. And most agents will ask that in a hot market. There's a lot to weigh up depending on where you're buying.
Yeah, well, we actually went through a similar situation where the client wanted to cool off, and we didn't want to pay the 0.25%. So we spoke to our conveyancer and we're like, hey, how do we get out of this deal? We don't want to pay the 0.25%. But we had a look at the disclosure documents that they sent through, and there was a spa in the backyard, and they didn't give us all the water certificates and disclosure documents for that, which then allows us to pull out of the entire contract without having to pay the fee. So it's always good to keep on top of what disclosure documents you're getting and what ones you haven't received, because that might be a bit of an out for you if you
So if a client needs to get out of a contract, even an unconditional contract, the first thing we say to them, okay, well, we can do a warts and all review of your contract and disclosures to check if there's any technical non-compliance by the vendor. And there's a few things that we look at that we know is relatively common that can be missed.
What are they?
That's
what are some of the more common stuff that gets missed? I mean, SPA certificates is probably up there, but what else you see?
Well, things like in Queensland, for example, if there's an easy one used to be, so if there's the dial before you dig searches. So if they have if there's some utility services running through the property, then that's there's a statutory encumbrance, and if that wasn't disclosed to you, then, and if that's material enough, if that runs right through the property, maybe you're planning to renovate, maybe you needed to or subdivide, that's material enough for you to terminate the contract. So a few things like that, but more often than not, it's maybe one of the in the vendor disclosure regimes. The vendor hasn't attached a particular document, or even, for example,
be good to bring that document back up, Joe, because I like structure. I like to see where we are in the process and talk to that.
Okay, cool. Let's do that. I did want to jump onto this one, though, this comment. And people throw in some comments. You have an amazing lawyer here that has crossed every single state. So if you want free advice, obviously it's not going to be specific advice.
But you have a good
advice. A very good opportunity here to take advantage. But they've written here lots of talk about buyer protection. How about if the seller wants to get out of the contract and there's no cooling off option for them?
Yeah.
So what are some of the more creative things that you've seen out in the industry and all the contracts that you've done that have allowed somebody to get out of a contract?
From the seller's perspective, there's certainly no cooling off for a seller. In the ways for a seller to get out of a contract really is if the buyer breaches or doesn't do something in time. So if, for example, in those states, if a buyer's negotiated a finance condition or inspection condition, usually they will need to give notice that they've satisfied or waived or terminate the contract by that particular time. So if it's 5 o'clock on a Thursday and the buyer hasn't advised that they've satisfied the building pest inspection, at 1 minute past 5, the seller can terminate the contract. So same for a lot of conditions. But usually it's at settlement time, the business end. So, and once again, varies between states. There were those time of the essence states where if you didn't settle, by 5 o'clock in the day, the seller could terminate, keep your deposit, and sue you for damages. That was the case in Queensland until very recently. But the contracts, the standard RFQ contracts, have been updated to give either party a 5 business day breather. So if the buyer's not ready, and usually they're not ready because of the bank, let's face it, banks are a major source of delays. And it's not always the bank's fault. Maybe the buyer hasn't returned the documents in time, but often it is the bank. And so they're not ready. So as long as the buyer, sends notice now in Queensland before, I think it's 4 p.m. thereabouts on the settlement day, they can use that 5 business day extension, right? But prior to last year, before the new contracts came out, if they were late by a minute, so I could terminate, keep the deposit. And this change came about because of a media story, essentially. A youngish couple were buying a house.
I think I saw that one.
Yeah. The older couple had moved to WA, and they didn't sell in time, and the older couple kept the deposit. Now, I think
it was like 300,000 or something, wasn't it?
Yeah, it was it was a lot anyway. It was a lot.
Yeah.
The bank ultimately in that story refunded the buyer, but that was at their discretion. I think just to keep the media at bay because it was a bad public relations.
People not tearing down their door.
Yeah.
I did hear a story recently, and I don't know if this is it's like secondhand, so it's not anything. I don't know anything really about it, but she was saying that she had a contract fully unconditional It went past cooling off. It went past the pest and building clause. It went past the finance clause. And we're just in that weird period between settlement and unconditional exchange. And in that time, the vendors had a divorce and the wife put an encumbrance on the property as ownership. And then she pulled out of the contract.
Yeah.
And then the banks saw that and said, hey, there's an encumbrance on the title that's above our lending. We're not going to lend to you anymore. What the heck happens in that situation?
Well, it sounds like it could be something like so where there's a family divorce or separation. Often a property is not even owned by both couples, right? So for asset protection, for example, our family home, it's my wife's name for asset protection purposes. And, I've got the properties in my name. But so even though that's the case, I'm still equitable owner. I may not be on title, but I'm equitable owner and I'm on the mortgage. But in that case where there was separation, the other party who wasn't on title would register a caveat over the property. A caveat is an instrument that on title that prevents dealings happening. So the owner can't then sell the property to someone else without that caveator knowing about it. So if that happened, the wife may have said to the husband, I want half the sale proceeds of this. And
unless you agree to it, then I'm not taking the caveat off.
Didn't take it off, and settlement failed because you can't transfer that title with a caveat. So that's possibly happened there. And then what does the buyer do? Well, you essentially you have to sue the sellers for breach of contract. But having the right to sue,
give you like what do you get for?
Well, you go to court and ask for specific performance or for damages. So the court can order, the sale to happen, or for the sellers to pay damages. But the court process is lengthy, uncertain, very costly. Most people try and avoid it.
Yeah. Okay. Cool. Well, what I think would be worthwhile is just start to finish going through the contract exchange process and the conveyancing process so people can understand it. Because the way I understand, people with conveyancing, it is I just need them to review the contract at the start, and then at settlement time, the mortgage broker, the conveyancer, the other bank just smash together in a room, and like I get a property, they get them keys. So it'd be cool to kind of lift the veil on what actually happens during that process. And would that be worthwhile for people? I think that would be ideal.
Talk through that.
Let's do that. What we'll do is we'll jump into our final sponsored video, and then we'll jump straight into that. Commercial property offers the highest cash flow in Australian property investing, offering exceptionally higher yields than residential. Now, we're talking 8 to 10% net yields. That's cash after all expenses, not this 2 to 6% gross that we see in the residential space. So for those that are starting out on their commercial investing journey, it can be exciting, but it's also a step not to be taken lightly. The expertise of a commercial buyer's agent can pay dividends to help you secure that high cash flow and high growth potential property. And this is why we recommend Steve Polisi of Polisi Property. With over 6 years experience in the space, Steve has over 1,200 property transactions under his belt. He has seen it all and knows the best locations right for growth. In a previous life, Steve was a chartered mechanical and structural engineer, so he draws on his mathematical and analytical skills that he's developed to break down what works best in commercial property. As with engineering, same goes with commercial property. It's based primarily on the numbers. So if you're curious about diversifying into commercial property, you have access to $100,000 in cash or in equity, book a call with Steve today and find that perfect asset for you.
Just gonna say, Joe, you there was a boat tour of Polisi on the weekend, so that was, I don't know how he's probably quite busy after that, but I also hear it's coming up to Polisi's birthday week, so there might be a special coming up on his book. But I really like that graphic, Joe. So let's talk. If we could talk through some of that. I know you said talk through it from start to end, so you bring it up and we can talk through some of those points. I think
we've deviated, haven't we?
Like a visual.
Yeah, no, I think it's an awesome tool that's going to allow us to be able to get a grasp, because there's so many, like, look how many steps there are. You're not forgiven for not understanding it fully. So I guess step one, what are we doing? We are, oh God, hang on, let me zoom in.
So you've talked through a lot of the.
So we talked through a lot of part A, I think.
So
getting a contract reviewed, getting in those states where it's like New South Wales, where it's essentially you're going into unconditional contract, or any state with an option, you need to get those pre-purchase reports, the building and pests strata inspection report if you're buying strata. Get that reviewed, get pre-approval done beforehand, and then we arrive at, okay, you negotiate the terms through the lawyers. You're happy with those terms. You're ready to sign the contract. So we can start from there if you want.
Yeah, perfect. Okay, let's do that. So let's roll.
Yeah, so contract signing. Well, back in the day, you had to sign a contract, by pen, wet ink, and it'd be posted or couriered between parties. It was a pain in the ass.
Well, that's not even that long since DocuSign and eSign have been normal. The last couple of deals that I did, I had to get something physically sent to me, and then I had to get sent back, and then someone else had to sign it, and we weren't in the same place, and it was a bloody nightmare.
It's pretty annoying.
We were, I guess, on sort of the frontier of this and pushing for electronically signed contracts, as long as 8 years ago.
Wow.
And we got initially a lot of pushback, and we'd call in favors or ring people we knew higher up in the banks, because the banks wouldn't accept it. Like, oh, this has been DocuSign, this has been electronically signed, where we need the wet signature. So there's a lot of pushback originally, and they slowly but surely changed their policies, and then that triggered the revenue officers to change their policies, because obviously you have to get documents stamped, and they for duty, and they refused, unless it was a wet ink copy.
Right.
So yeah, it's been a long journey, but I think we're there now, and everyone accepts DocuSigned or electronically signed contracts. So
and I think COVID really accelerated the last 2 years as well. Like, I think there was some law that passed. I don't remember as what it was, but there was some ruling saying that we can totally accept digital signatures now.
So, well, the law's been in place since about 2000, turn of the century, but it just wasn't put into practice. So, Electronic Transactions Act around about 2000, 1999, Commonwealth, I think 2000 in most states. So it's been around for a while, but it wasn't and there was some uncertainty with companies. So because it was federal law and the Corporations Act. Yeah. So that recently they've changed the Corporations Act, so now it's very clear that companies can sign in accordance with the Corporations Act electronically. But also prior to the recent changes, whilst individuals could sign contracts electronically, there was some uncertainty, or they couldn't do so with deeds. And that's a deed is a special kind of document, as opposed to any other sort of agreement. So there was a higher threshold, a higher bar for signing deeds. And most states have now changed the law recently to allow for electronic signing of deeds as well, including mortgages. Yeah. So this is still pretty fresh, and a lot of banks don't. We give advice to banks and fintechs as well about this, but even though the law now allows them in a lot of states.
Can I throw in a question? What are your thoughts on, this is probably a question on some people thinking about, thoughts on digital contract on the blockchain? Have you investigated much? I mean, if you can't share too much of sort of proprietary information, let us know, but has there been many thoughts on that?
Yeah, I mean, it's good in theory. And I think people are working on it, but I think it's a long way off. Okay. What we're looking to do though is developing a national contract. Every state has their own standard version of contract. But how great would it be if you had a national contract and it's not easy because there's essentially 8 different countries in Australia when it comes to property law. So it's a difficult job, but something we're looking at. It really only takes a player in the market with enough market share to start requiring these contracts to be used for it to take off. So
how likely do you think that will happen?
I think it's likely. The question is when. And then because there's a lot of industry players to accept it, you've got the real estate institutes, the banks, and things like that.
Yeah, actually, there's a question for you. Which of the states are the most fair, not for the vendor, not for the buyer, but just the one that makes sense for everybody? Like,
most balanced.
Yeah, what is the one that national contract would be, do you think? Because I think South Australia has a 2-day cooling off period where you can just walk. Like that's not okay. You can't just do that for whatever reason. I don't think that's fair for the vendor. WA, you can just you sign the contract, it's done. Like I don't know what state is making sense the most for this national contract, you reckon?
It's a controversial question.
It is, yeah, and I think it's difficult to say which one has the best balance because they're competing interests, aren't they? The vendor wants to be locked in as quickly as possible, unconditional, and settle without many rights to get out, and the buyer wants the opposite. So from a buyer's perspective, Queensland's got a great contract for buyers because it's very common to have those finance and building pest conditions, and it's better now because of that 5 business day extension, right? But then the contracts and the practice in New South Wales is heaps better for sellers because it's practice to make sure that the contract is exchanged unconditionally.
Yeah.
But that can obviously give rise to gazumping, of course. So gazumping is where you're not locked in. Yeah, you're not locked in. So you're negotiating, buyer and seller negotiating something, negotiating the deal. The buyer's doing all their, pre-purchase inspection reports. They've agreed a price through the agent with the seller, and they're almost ready to exchange, but haven't done. But then the seller gets a better offer from someone else. And because that first buyer hasn't exchanged on the contract, no one's legally bound at that stage. Another buyer comes in, exchanges beforehand, they get the deal. That first buyer has been gazumped. So it can happen, and it would happen more so in those states where it takes longer to exchange because it's unconditional exchange. But of course, balancing that is, agents would get a bad reputation if they allow gazumping to happen on their watch. It's probably more likely to happen directly when a buyer and seller are dealing direct with each other.
Yeah. Okay. So what states are more gazump friendly? Like I've never been gazumped in Queensland. Actually, I've never been gazumped at all. So I like the word.
It's a good word.
It's a bloody It is. It's probably what it feels like. Like named it perfectly.
Onomatopoeia, right?
Yeah. Well, the states where you can go to contract super quick, it means less chance of being gazumped. So if you're buying a house in Queensland, or WA, there's a standard form of contract. An agent can complete that contract. It doesn't have to go through a lawyer. You can sign that contract with the agent straight away. Obviously, not necessarily a good idea to do that because you haven't had the contract reviewed or advice on it. But yeah, if you have to move really quick, maybe add some special conditions so you can get out of that contract later if you haven't had a chance to have it reviewed. Sometimes we see special conditions saying, this contract is subject to the buyer solicitor reviewing this contract and being satisfied with this contract within 2 days or whatever. So if you do have to exchange real quick, add something in like that.
It's actually a really good point. I was just having this discussion with a client yesterday, and we exchanged a contract really late at night, like 8 p.m. We were working on a deal, negotiating, and she's like, the agent's like, we need this contract now, or you're not going to get it. The open's tomorrow. But this was like over the weekend. The open's tomorrow. You're not going to get it unless you sign it, and we get it fully exchanged. Now, we're like, well, we need the conveyancer to look at the contract, obviously. So they need to legally go through what they're doing. Now, in South Australia, they have a mandatory requirement for a 2-day cooling off. The only way you can get rid of that cooling off is to sit down with the lawyer and get them to waive it watch you sign a document and waive it, like the 66W in New South Wales. So you can actually sign a contract in South Australia and then sign it, whatever it says on it, then the next day get it reviewed by a lawyer and make sure that everything's in space. If something's wrong with it, then you can just cool off and get out of the contract.
Yeah.
So you
can negotiate contract changes during the cooling off period if you have a cooling off period.
Yeah. Okay, cool.
Going back to that. Yeah. So contract getting it signed electronically.
Yeah. Well, let's just kind of go high level snapshot overview, because I think that this point here is a very good point. You've got to choose the person that you actually want to go with. Then in between this point and this point, there's actually quite a lot in terms of finding and identifying and negotiating on the contract. Then we receive the contract, right? So we speak to the real estate agent. Hey, I really like this deal. Send me the contract. I'm interested. Send me any disclosure documents. That would be amazing. Then you take that contract to your legal advisor, and then you say, yes, this is something that I think is really worthwhile. In the meantime, you're already looking at the property. You would have already gone to the property to check it out, or you're going to it at the weekend. You would have already spoken to your mortgage broker and built up that financial approval. If you're buying it at an auction, you would have already done a property inspection, and you also would have already read through all the contract and any disclosure documents. Then what happens is you then put forward an offer to the agent, which is going to have your clauses and your contracts in there. What are the special conditions that you want? And maybe we should touch on some of the more popular ones. Actually, let's just touch on that now. What are some of the most popular clauses and things that you see in contracts? So maybe I'll go through some of the more common ones, which is I want a pest and building clause in here, and I want a 14-day finance clause. What are some of the high value
Depends on the state,
ones?
because that's not like you don't get a 14-day cooling off. I mean,
Sorry, did I say cooling off? 14-day finance clause. So a 14-day finance.
The finance clause is often disguised as a cooling off period in New South Wales. So rather than asking for a 14-day finance, just say 14 days cooling off, because you can negotiate. There's a statutory period minimum, unless it's waived, but you can negotiate a longer cooling off period. So they're the big ones. We touched on due diligence before. You might even want to narrow the scope of due diligence. So we spoke about unapproved structures. So you might want to say contract subject to the buyer being satisfied that all the structures have been approved on the property. That might be another 14 days to do that. It's also, I see a lot of it's becoming a lot more popular where there's subject to sale clauses. So if it's a downsize or an upsizer, well, I'm going to buy a property first, lock that in, but I need to make it subject to me selling my property. They can get complicated, but are often needed. If you have the ability to negotiate, that's great. And it becomes a bit of a chain, like in the UK. So in the UK, a lot of sales, other than first home buyers, they're all chains. So they have all these contracts sort of linked together and subject to each other happening. And something doesn't happen on time, and you could be waiting months and months and months for your settlement over there. So starting to see a bit more of that happening in particularly in slow markets. That's pretty common.
David's put here electrical and gas clause. What is he?
That's sort of kind of unique to Western Australia. So it's one of those that they have some industry standard annexures that they attach to a contract. Structural defects, pest, timber, electrical and gas, just to make sure they're in working order, essentially. That's recommended for WA for existing properties. That
allows you to skedaddle, or the vendor has to fix that issue, right? You can't just end the contract. The vendor can say, oh, I totally appreciate and I identify that there's a gas issue. I will have that fixed, and that clause you won't be able to escape for whatever reason. It'll be fixed and you can't escape the clause.
Yeah, it really comes down to the terms of the special condition annexures there. And I know in our practice, we thought some of the industry standard ones weren't great for buyers, and so we submitted our own drafted versions on behalf of clients, and were just rejected outright by conveyancers in Western Australia. And so what we ended up doing was changing the font to look at just like the industry standard font, and they were accepted. So, which seems bizarre, but people just wouldn't read it. They just assume, oh well, that looks normal. We're comfortable. We're used to that. Well, that's fine. We'll accept it.
Have you seen that happen in a contract where an agent does that? They put like a crazy condition, but then they move it somewhere and they put it in a similar font that looks like the stock standard. Have you seen that happen before? I mean, you guys are doing it clearly, but
yeah. Well, agents aren't legally allowed to draft clauses. Okay, so drafting special conditions in a contract is considered giving legal advice. What agents can do is copy paste special conditions that have been drafted by a lawyer or conveyancer and put them in a contract. But they can't actually just come up with their own, because that would be only lawyers can do that, and it'll be it's illegal essentially. So if they were to do something like that, if they were to rearrange especially a lawyer draft or something standard, there could be implications on that. But I think the bigger thing for property investors to know is that when buying off the plan, of course, there's very often they don't use the standard contracts, and that very bespoke contracts, particularly for apartments and townhouses. There's no legal requirement to use a standard form of contract. Of course, you can use any contract; it can be one pager, as long as you have all the statutory disclosures and things like that. So if you're buying off the plan, you really, really need to get a lawyer to look over that, because they can put in any kinds of terms. And sometimes developers will make their bespoke contracts look standard, have the look and feel of a standard one, to make buyers feel comfortable about it. Even buying off the plan, one today that I saw, it was a standard RIQ contract, but then, and then they have all the terms and conditions in 2 columns. That's sort of the standard RIQ version, and then they had their own special conditions also in 2 columns. Same font, looked exactly the same. So to the untrained eye, that just looks like a normal contract. But of course, those special conditions completely change the standard position in the contract.
Wow.
Yeah, it's amazing the wording of it. I don't want to go into this.
Sorry, Jeff. I think let's just kind of hit onto this, because I think this point here is a big point to talk about as well, with the contracts exchanging, right? So we found our deal, we've negotiated with the agents, we've got a 14-day pest and building clause, we've got cooling off period, and we've got a pest and building clause and a finance clause for 14 days. So when generally speaking, you sign it as the vendor, as the client, and then it's sent off to the real estate agent to give it to his vendor. So what does that situation look like, right? There's that kind of limbo period.
Yeah. So it really comes down to practice. In New South Wales, where the term originated exchange, both parties would independently sign their version of the contract, and they'd have those. And when they were comfortable with all the terms, the lawyers would exchange those. So that the purchaser copy would go to the vendor solicitor, the vendor's copy would go to the purchaser, and that would be exchanged. WA, the offer and acceptance, so the buyer offers, the seller accepts by signing, returning that contract. In Queensland, it's common for the agent to say, submit your offer, which means sign a contract. The buyer signs a contract. If the seller accepts those terms, they will countersign that contract. It's a fully executed and exchanged contract. But it doesn't. There's generally no legal requirement for either party to sign first, except when it comes to some disclosure documents. Sometimes the vendor has to sign a disclosure statement first before giving that to the buyer. But in what happens in practice now with DocuSign is that the agent or lawyer will send it to the buyer first. They'll sign it, and then it'll be routed to the seller next, and they'll sign and date the contract.
Yeah, and these are situations where you can get gazumped, right? Like if you sign the contract on a Friday, let's say, go back to my example before. So you sign the contract on a Friday, and you're like, yeah, I'm going to pay this price, but I don't want you to go to the open home tomorrow because I want you to exchange on the contract and it's mine. They can then go to the open home and say, hey, everyone, I have a $500,000 contract here, just letting you know. If you want to bid any more than this, let us know, because this is the contract that we got. And then they bid up more prices, and then they say, well, actually, I've got 520. Then the agent comes back to you, and I'm like, yeah, look, really sorry, we have a 520 offer now. Your offer is now not the best one. We're going to go with this one unless you can match or beat it. So you do have to,
that's a bit of a Dutch auction, they say. With it.
I think in some things more where, and correct me wrong, some things where both parties verbally agree. Like in your situation, I mean, I don't know.
It can still happen though after the buyer's signed. Yeah, the seller may accept another offer. That's that can happen. A Dutch auction is Dutch auction is when it's not real auction, but then the agent's saying, okay, well, this person's offered this much, and then that person, you keep going up, kind of thing.
And everyone hates an auction, until they've had a terrible private treaty, like those type of experiences are like, I wish I had an auction, because it's all transparent. Everyone's got their hands up, exactly what's happening. But you can kind of see through that, agent, all the agent games.
And buyer games as well. I think poor agents get a bad rap. I mean, buyers are often sort of playing many sort of fields. Well, as we sort of, I want to respect you. You've given so much time and so much value. I wanted to know that, Richie. A question I was curious on is, how do you how would you select? Say somebody has going out there looking for a solicitor or a conveyancer. How do you pick? I mean, of course, what kind of questions should people be asking to make sure the professionals know what they're doing? Well,
I think number one, making sure that they actually practice and have experience in that jurisdiction, because the laws are different in each state. But how do they deliver their service? Is it easy? Is it quick? Is it efficient? Will I have to spend time coming into the office, or can I do it all on my phone or online? How will you identify me? So that's a big part of the process, because settlements are electronic now. There's a very high threshold for lawyers and conveyancers. They're the gatekeepers for electronic settlements. So they have to do a face-to-face verification of identity with all their clients. But that face-to-face can be essentially outsourced to the likes of Australia Post and other providers, where the client goes there and does it. But, for example, we have a tech solution for that. So they can actually use their phone to take a selfie of themselves and a photo of their original identity documents, passport, driver's license, then nominate someone who knows them to do the same. And that information is checked against the database, the government databases, and produces a pass or fail report. So, so that question, well, can you make it easy for me by having these digital solutions to save me time? I mean, the conveyancing process isn't necessarily exciting for most buyers. The exciting process is finding the property and buying it, exchanging it, and then ultimately moving in. The conveyancing process between buying it and moving in, or settling on it, is kind of that awkward thing that we don't, we have to have, but we don't, necessarily enjoy it. So
that's the funny thing. We've gotten to like the fun part, and now the next couple of steps are like, cool. Yeah, we don't care what happens after that. Like, let's just not even talk about it. It's fine. We're not interested.
Because most buyers, they don't really care or understand what happens. They just want it to be as easy as possible. But that process, if you choose the wrong lawyer, that can be extremely stressful. One of the most stressful times, because you're having to get these things done and sign documents and do this and do that. Particularly with the fight, there's two streams: there's the finance stream and the conveyancing stream. And if the lawyers aren't on top of and making sure things are done on time with the finance stream, that can delay settlement. And delayed settlements are one of the most stressful things, particularly when you've got people, packed up, ready to go, or packed up and ready to move in, and they're waiting outside, or it's going to settle at 2:00, but it doesn't. It gets delayed by a few days, and they've moved out, and they've got nowhere to stay. And if you don't plan that, and if the lawyers don't educate their customers about what can go wrong, or at least prepare them to have a plan B, or maybe don't. They might assume that it's, oh, how many times do buy? I mean, investors buy it more often, but your average home buyer once every 7 years or 10 years, whatever it is in Australia. They just assume, oh, it's settlement date. Okay, well, that's the day we move. But there's lots that can happen.
What are the, once you've gone unconditional on the contract, what are the steps in between from a conveyancer? Because you've got a couple of steps. I don't know if you want to bring that up, Joe. We can talk to that quickly. That'll be the wrapping into.
So we signed the contract. Before we signed the contract, we after the sign the contract. So you've ordered the searches, we've satisfied our pest and building time, and now we know the settlement. Is that where we're at now?
Well, I'll touch on the deposit. I'll touch on the deposit quickly. So, and this varies between states as well. But for example, New South Wales, you usually pay the deposit to the agent's trust account, lawyer's trust account before you exchange. But in other states, you might pay it, a day or two after, or sometimes, for example, Queensland, it's quite common to pay a small deposit up when you sign the contract, but then the balance of the deposit 14 days after when you get finance approval, or when you go unconditional. And the deposit's negotiable. At an auction, it's usually 10%. Sometimes you can negotiate down to 5%. But in a lot of states, you can negotiate that deposit. I mean, from a buyer's point of view, you want the deposit to be as low as possible. From a seller's point of view, you want it to be as high as possible, because if the buyer defaults, the seller keeps that deposit, right? So the seller wants more, and the buyer wants to reduce their risk.
And actually, a point on that, and we actually had this on the session. Sorry, I know it's not your fault that we're not getting through this, Richie. It's entirely mine. Is to make sure that the deposit that you put in when you are negotiating, if you do want it to be as low as possible, make it about 3%. Don't try and go 1% or 2%, because that doesn't cover the real estate agent's commission. And he's very interested, or she is very interested in making sure that she gets paid when if there's an issue. So always think about that when you.
Absolutely.
So you're nodding your head, Richie. You must hear that a little bit. Is that what's the number for you? What is it?
Enough to pay the commission. Yeah, that's absolutely right.
Yeah,
absolutely right. So, and that's usually no more than 3%, right? So that's a good number.
Cool. I thought I'd just jump that in. Sorry, go on.
But time is of the essence with paying the deposit. It's an essential term of the contract. So in contracts, there are terms that you must do, and then there are essential terms. And if you don't do something that's essential, that then creates a breach. In some states, the seller has to give a notice to remedy that breach in a particular time frame. It's not done, they can terminate the contract. So, but in other states, if that notice isn't required, and if you haven't paid on time, they can terminate the contract straight away. And you might have paid, let's say the deposit's $10,000, you might have paid $5,000 by the due date, and then you don't, you're planning to pay the balance a few days later, but you haven't asked your lawyer to extend that deposit payment date. You'd be in breach of that contract. The seller could actually terminate and keep that $5,000 deposit you've already paid.
Yeah.
So really important, if you're going to pay a deposit late, to make sure you first get the deposit payment date extended and agreed to by the seller.
Wow. Okay. That's a very good point. Very, very good point. I bet that happens a lot. And then people just kind of breeze over it. But there can be people that just say, no, I'm keeping it, canceling the contract, and I'm going to go elsewhere.
Yeah, there's been plenty of cases about it.
So, okay. So what exactly are property searches? Like, you hear this thing, property searches. What is it?
Well, going back to those buyer beware regimes, where the seller doesn't attach any of the searches about the property, these are the searches that the buyer needs to do to make sure there's no issues with the property. So obviously those compulsory ones we spoke about, the title, the plan, the land tax, the rates, the water, but also those other things, like the council approvals, like the main roads, heritage building, things like that. And that, there's usually there's a list of these in each state, and there can be as many as 20, sometimes 30 potential searches you can do for a property type. And it's up to a buyer to really consider how many of those they do, and they often say, well, you tell me. And so what we do anyway with our search lists is for each search. We have a little explanation. So you should consider doing this if the property is of this type, right? And so they can then work out, okay, well, the property's not this type, so I'm not going to bother with that kind of search. But these searches can add up to be, hundreds and hundreds of dollars. But of course, hundreds of dollars isn't a lot to protect and manage your risk when you're buying hundreds of thousands of dollars worth of property.
So let's say we've gone unconditional on our contract. What is like behind the curtain? What is the behind the curtain stuff that we're looking at that conveyancers do? So they do the property searches, they set up and do stamp duty. So making sure that exact number is up and set up correctly.
Yeah, the stamp duty, and there's forms to complete for that, and there may be concessions or and discounts in certain states for certain kinds of buyers. Generally, for property investors, there aren't, unless you're buying off the plan in some areas. But you still need to complete forms in that regard. And then the next one was obviously signing the mortgage documents is critical to do that as quickly as possible, because that's going to be the number one cause of delayed settlement. And your bank's going to send that to you directly. Broker's going to organise that for you. Where we might get involved is where there needs to be independent legal advice on a guarantee. For example, if you're buying a company of trust, the bank will want personal guarantees. They'll want to send you to a lawyer to get independent legal advice about that guarantee, you personally guaranteeing that loan. On this, traditionally, most states still, technically, the Law Society's position is that you need to see someone face-to-face in their office to get independent guarantee advice. But in New South Wales, they do accept it being done remotely. So what we do is, doesn't matter where you are in the country, we get one of our New South Wales lawyers to organise a video conference, for example. We give written advice before the meeting. We watch you sign the guarantee documents, video record it, scan an email copy back, we countersign, put the necessary wording and forward it on. So it can be done remotely, which is good in that process. But otherwise you have to go and see someone face to face. Yeah.
Okay, cool. Well, what we'll do, we're getting kind of close towards the end of the show. Anyone that has any kind of questions, throw them into the little comment box in there, and we'll jump on and get on in there. But yeah, let's kind of wrap up around this side of so after the settlement. So we've done the stamp duty, we've signed the mortgage documents, we've let go any guarantees, and then settlement figures.
Settlement figures, yeah. So we work out settlement adjustment sheets, so price less deposit less outgoings for adjustment, because seller's responsible up to settlement, buyer's responsible after settlement. So we work it out, we get a final balance plus your stamp duty plus your legals. This is how much you need, less what your bank's advancing. Transfer this amount into our trust account. We then move on to settlement. Fortunately, in most states we can settle electronically. So we've got every state except for NT and Tasmania can settle electronically now. So people might go to PEXA, the Property Exchange Australia online settlement platform. Now they do have a competitor called Simply, but they're not ready for end-to-end settlements yet. So rather than turning up in person like in the old days, where you get all those people in the room you mentioned at the start, swapping the documents, it's just an electronic version of that basically. But the great thing about it is it happens all at once, so that the transfer of title happens usually straight away or by the next day. The money's in the account straight away, rather than having to wait for bank checks to clear and take several days to get your money.
Yeah. Okay. Well, one thing I've got the question of is around the settlement figures, to go back to it, is that's if someone's paid their council rates for a full year, for instance, you would then say, well, look, this person is owed 9 months of settlement, 9 months of council rates. Is that how you guys kind of come up with the settlement figures?
Yeah, that's right. It's going back to those property searches that are compulsory, for the rates. So if you have paid a 6 months or a year of rates in advance, then that gets adjusted pro rata between the parties. So seller's responsible for settlement, and then you do an adjustment. So you essentially repay them for that period that they've already paid for in advance. The big one to look out for is land tax. So land tax can be adjusted between the parties if it's a contract term. It's not common. It's certainly not common for owner-occupiers when they're selling a house to have any land tax, so it won't be adjusted. But if you're buying off the plan, the developer often wants land tax adjusted. New South Wales contract, there's a tick box in the standard contract form about adjusting for land tax. So that's one to look out for, because if you buy a property, and land tax periods change between states. So land tax year, land tax assessed on 31st December in New South Wales and Victoria, I believe, every year, but in Queensland's 30 June. So if you're settling in New South Wales early in the year, and you've agreed to a land tax adjustment clause, you could be paying, best part of a year's land tax back to the seller to pay them back for that, even if it's an owner-occupied house that you're buying, because that's just a contract term. So that's a big one to look out for. You don't want to pay someone else's land tax.
Is that something you see happen? Is that a pretty common one, Richie? Or you seen?
Well, you try and negotiate out. So if a property investor was selling their property, they'd want a land tax adjustment clause. They'd want to recover land tax they've paid, for the whole year if they sell the property to someone else. And a property investor may say, well, okay, that's fine, but an occupier might say, no way, I'm not paying land tax. I'd never have to pay land tax if it was my own occupied property. So it comes down to negotiating that. Then developers, depending on your bargaining power, they'll agree to a land tax, to remove a land tax adjustment clause. So that's one of the things that we always recommend a buyer considers changing.
Wow. Yeah. Okay. I didn't know that about the whole land tax side of things. Because if you're an owner-occupier, you shouldn't be paying it. But
it comes down to contract terms.
Yeah.
So very important.
Yeah. I've really enjoyed this session. I think that there are so many different little contract clauses and things for all the different states, and I think we covered a whole heap off. Like if you listen to the episode in its entirety, you could piece together what you should be doing and what you shouldn't be doing in the different states. So that was really the goal of tonight.
Bit of a brain dump. Yeah. So hopefully, the audience has got something out of that applies to them.
Oh, definitely would. I got to ask you. I'm interested. What are some of the more creative clauses you've seen buyers look to negotiate on, and have they been successful at doing so?
Well, listen. A lot of the time, they might negotiate for works to be done. Just put it straight in the contract. Well, I want these works to be done by settlement, and not settling until that's done. Getting stuff fixed up, or negotiating for early possession, so getting in there. If the seller's not still living there, if it's investment property or they're not tenanted, or they've already moved out, getting in there early before settlement, doing a bunch of works to the property, renovating it, doing all that work before you settle, so that when you do settle, you're able to rent it out straight away. There's obviously some risk with that, so depends how much you're spending on the renovation work. You don't want to spend hundreds of thousands, and then the vendor defaults and you can't settle. Or you have to sue the vendor. So you've got to weigh that up.
Or the vendor says, that's not the renovation that I wanted. You have to pay me to remove all of this crap and replace it with new stuff that I want. If for whatever reason you can't settle and buy it, you're going to have to then pay the seller the cost of rectifying it and putting it back to its original and I think
condition.
that the other clause that you spoke about is early access, is where it's super valuable, where you go in there, you measure everything. There's a 14 days left of the settlement. Get your inspector, get your electrical guy in there, get your carpenter in there, get all your trades in there that you need, your carpet layer, quote up all of your jobs, and then map out the session for the job if it's a renovation, for instance. And then as soon as you settle, boom, this guy's on the phone. They already know. And you're starting this day, you're starting this day, you're starting this day, you're starting this day. And then you can clean it up really well. You've already done the measurements. You've jumped in there early. But I wouldn't recommend doing the work beforehand, because that's where you're going to get into some trouble.
Yeah, no, absolutely, yeah, that's important. And off the plans, though, there's you want to be able to get in there with a handover inspection and make a list of defects. Usually with off the plan, there'll be a defects rectification period. So the builder developer will have to rectify defects that you advise them of within a certain period after settlement. But potentially, you could, some of those defects might be significant, so you want to make sure they're fixed before settlement. Or some of those contracts may say that if you don't give notice to the developer of any defects before settlement, then you've got no right to get those rectified after settlement. So you want to make sure the contract terms give you the ability to go in, check the defects, give that notice before settlement.
Can someone settle a property without a conveyancer or a solicitor? Can they actually just do it all themselves?
Well, number one, they'd be crazy too. Going back to the quote of the day about a person who acts for himself has a fool for a client. But secondly, in those electronic settlement states, which is most states now, in New South Wales, Victoria, it's actually compulsory to settle electronically. So you can, essentially, by that you can't settle yourself. You have to engage a lawyer or conveyancer to settle, because they're the only ones who will have access to PEXA.
You have to have access to PEXA to be able to do that. Yeah, right. I was just wondering, because I've never heard of anybody. I've heard of people managing their own properties, but I've never heard of anyone saying, you know what, I'm going to take on the conveyancing by myself.
I've seen, we've dealt with from time to time, particularly in Queensland, because it's electronic settlement isn't compulsory; it's optional. Both parties have to agree. But yeah, maybe retired lawyers or conveyancers, or maybe property investors who've done so many before, they kind of use the process and they just, they're comfortable doing that. So,
well, let's jump into the questions. If there's any questions, we've kind of been sprinkling in the questions throughout the time. I don't think there's too many. Don't think there's too many in there, because we've kind of been answering them as we go along. But one of the questions I wanted to ask you, Richie, is what like, because you work with Law Lab, you pretty much, I don't know if you want to say you run it, you're the head honcho,
legal director.
Yeah, but, legal director. So,
well, what's the difference between Law Lab? Because I used to work at a legal tech company, and we used to put all of our work through Law Lab, because you guys are efficient, you get the job done quickly, you get it done efficiently, and you're very, very affordable for the work that you do. So what is the difference between Law Lab and a normal kind of firm? Like, how do you guys do this?
Well, the way we can actually deliver a national consistent service is using tech. So our service is a combination of tech and lawyers, and so for example, one of the tech tools we have is called Rundle, which is a secure online platform which brings in the buyer or seller and their broker, the property investment advisor, agent, and so including us. And so we're all working together in this secure online platform, communicating, sharing documents. There's a workflow of timelines, so everyone knows all the key dates and has access to the documents. And of course, within that platform, it makes we're more efficient, because at key steps of the process, there's videos for customers. Okay, traditionally lawyers would send out letters and heaps of letters, right? And no one reads those. So we found a quick 60-second video at 4 key steps during the transaction makes people aware and understand of what's going on and what needs to happen. So
what videos are those steps? Like what are those videos and what are those key steps? So
so from memory, before you sign the contract, and then after you sign the contract, what happens next, and then coming up to settlement, what they need to do, and then after settlement. 4 key steps, and obviously with integrations within that. So we've got the DocuSign integration, we've got that verification of identity, we've got a few partners we work with to provide quick and easy building reports and things like that. And of course you don't have to live in that platform. It's mobile accessible, of course, but you still get email updates and you can respond to those emails, and it's uploaded automatically. So it just makes the whole process a lot easier and a lot quicker for our customers. And of course, being a law firm, we've got 40 odd staff, and most of those are lawyers and conveyancers, so they're experienced in each of their jurisdictions.
Yeah, and that's it, right? And you have some standard service levels around. Like one of the things that we were talking about is the speed to the deal. Like it's very important to be able to work with your conveyancer and move fast. And you guys move fast on deals as well. You have like a quick turnaround for contract.
Yeah, we've got standardized service levels. So we say to our partners and customers that we'll respond to any comments and rundle within 2 business hours. Of course, you can still phone us. We've got a support team on the phone. Our support team who answer the phone have previously been conveyancers themselves, so they can often just answer your question off the bat. And of course, with contract reviews, at most it's going to be the next business day. But if someone calls up on a Friday morning saying, "Oh, there's an option on Saturday," then we'll do our best to get that contract reviewed by the end of the day.
Yeah, this is there's a question that's popped up here that's from David. He's saying, how much time goes into conveyancing? It kind of feels like half a day of effort to me.
Well, it's one of the most highly regulated professions, being a lawyer, and the amount of claims against lawyers' insurance comes from conveyancing. So it's the most risky type of law from a practice point of view, and obviously for each of the states there's not just one law, it's not just one property law. There, for any kind of conveyancing transaction, there can be as many as 30 or 40 different pieces of legislation that you need to consider. So listen, if a transaction goes really smooth, the amount of work that goes into it, over the course of a month or 2, depending how long the settlement is, it might only be 5 to 10 hours of work if it goes really smooth.
Wow.
But not all
so much
transactions. Not all transactions go smooth. So things need to be extended. There are arguments or disputes over things. So it's a lot more than you think.
Yeah, and a lot of like when you say you haven't paid the deposit, okay, you need to tell your conveyancer, they need to call their conveyancer, change the contract. You have to look at that clause, make sure you're happy with it, and re-sign it, and then back and forth.
Yeah. You need lawyers traditionally charge an hourly basis, right? So my hourly rate is close to $600 an hour. But of course, if I was doing a conveyance myself and spending 5 to 10 hours, I wouldn't be charging. We can't charge $3,000 to $6,000 in every conveyance. So we have to have systems and tech in place to make it more efficient and use more junior lawyers, and things get escalated up where they're needed to more senior lawyers. We've got an online quote tool which gives an instant quote depending on your state and property type without entering any personal details. So anyone, including our competitors, can get our prices online. We're transparent about that. And they're very competitive fees as well. So you need to be, because it's a competitive market.
Yeah. I think based on the questions, we don't actually have too many that we haven't already answered. But the question I think you've already answered, but does the Law Lab cover the whole of Australia and know each of the different states? And I think the answer to that is yes. You cover absolutely every state, every transaction for purchasing both residential and commercial. Is that right?
Yeah, we do commercial. It's not a large percentage of our business, maybe 5 to 10%. But yeah, residential is most of our business.
Yeah.
David said, thanks guys, amazing value. So it's more than half a day's value, David?
Well, yeah, I think you covered an amazing spread of information, but you've given us a full understanding of the conveyancing process. What we'll do is we'll pop that document into our group as well, and we'll have a bit of a recap follow up of some of the things that you chatted about. But is there anything else you wanted to cover off that is worthwhile mentioning that we've missed?
Well, we've covered a lot, so happy to leave it at that. I will say that if there's any follow-up questions, on the group, I'm a group member, so I can jump in and answer things.
What's the best way to reach out to you and also reach out to Law Lab?
Yeah, Law Lab, website, lawlab.com.au, instant quote tool. If you like the quote, you can actually start a conveyance from there. so you can onboard yourself essentially. And
Thanks,
yeah,
DJ.
feel free to reach out to me on Facebook or LinkedIn.
Yeah, thanks.
Awesome.
Thanks very much for jumping on. I appreciate that you make it you make it sound very very straightforward and as I mean, it doesn't always go according to plan. I've in a couple of property transactions, mine haven't always gone according to plan, so hasn't been always the lawyer's fault. But yeah, you make it. I'm sure you put a lot of people at ease with the way you've presented the information. So thanks for jumping on, Richie.
Yeah, and I mean, after we've managed over 50,000 transactions, so we've seen it all, and it's being prepared for those things that we know could be problems. We prepare for it earlier on.
Yeah. Thanks very much.
Perfect. Well, I just wanted to, thank you very much, Richie. That was an awesome summation. And if anyone wants to reach out to Law Lab, jump on the link there, check it out. It's an awesome way to go. But yeah, signing off. Let's go buy a property. See you guys later. Thanks, Richie.
Thanks.
See ya.
Thanks
Thanks,
everybody.
guys.
Happy Father's Day to all
Cheers.
of that.